Today, we're diving into the fascinating world of South African law, where everyday actions can have unexpected legal consequences. Our focus is on a crucial area called the law of delict, which is all about civil wrongs and the responsibilities we owe each other in society. In simple terms, a delict happens when someone causes harm to another person, physically, emotionally, or even financially, and the injured party can claim compensation for their loss. But not every case is straightforward. Today, we're zooming in on two important defenses that can change the outcome of a delict case: provocation and consent. Provocation is when someone pushes your buttons so much that you lose your cool and act in a way you normally wouldn't, like lashing out after being deeply insulted or taunted. Consent, on the other hand, is when you willingly accept a certain level of risk. Think of agreeing to play a rough sport like rugby, where injuries are part of the game, or signing a waiver before an extreme activity. These defenses are powerful because they can reduce or even eliminate a person's legal responsibility for harm, depending on the circumstances and how the court interprets the facts. For example, if you lose your temper and punch someone after a severe insult, the court might see your reaction as understandable, and provocation could reduce the damages you owe. Or, if you get injured during a rugby match, your consent to play means you accepted the normal risks. Unless, of course, the tackle was illegal or far outside the rules of the game. Understanding how provocation and consent work in real life helps us see why these defenses matter, not just in courtrooms, but in our daily interactions and choices. Provocation is a legal excuse for reacting in the heat of the moment. It doesn't erase your responsibility, but it might reduce the damages you owe. The provocation must be so severe that any reasonable person would react similarly. Your response must be immediate. No delayed revenge. For example, if someone dumps ice water on you in winter and you yell, the court might go easier on you. But a minor annoyance won't cut it. The law expects self-control unless the provocation is extreme. How is provocation different from private defense or self-defense? These two legal concepts are often confused, but they have very different meanings and consequences in the eyes of the law. Understanding the distinction is crucial, especially in criminal cases where emotions and immediate threats can blur the lines. Private defense is about protecting yourself from an immediate threat. If someone attacks you or puts your life in danger, the law allows you to use reasonable force to defend yourself or others. The key here is that the danger must be real and happening right then. Your actions must be necessary to prevent harm. Provocation, on the other hand, is about reacting emotionally to a situation. It's when someone's words or actions make you lose your temper, but there's no actual threat to your safety. The law recognizes that people can act rashly when provoked, but it doesn't excuse violence. Let's look at a real-life case to understand this better. In this case, a man killed his wife's lover after being taunted and humiliated. He claimed he acted in the heat of the moment, unable to control his emotions. The court found him guilty. Provocation didn't excuse murder since there was no immediate threat to his life or safety. The law is clear. Feeling angry or insulted is not the same as being in danger. The lesson here is important. Provocation might reduce your sentence, but it won't justify serious crimes like murder. Acting out of anger is not a legal defense. Private defense requires a real, immediate danger to yourself or others. Provocation is simply about losing your cool, not about saving your life or preventing harm. The law draws a clear line between the two, ensuring that only genuine acts of self-defense are protected, while emotional reactions are not treated as justifications for violence. Now let's talk about consent, a powerful and sometimes misunderstood defense in delict law. Consent means that a person voluntarily agrees to something, fully understanding the risks involved. But how far does this agreement really go, especially when harm is involved? If you agree to take part in a risky activity, like playing rugby or going bungee jumping, you're accepting that some level of harm or injury might happen. This is because these activities naturally come with certain dangers, and by participating, you're saying, "I understand and accept those risks." There's a difference between consenting to injury, like when you get a tattoo, knowing it will hurt, and consenting to the general risk of harm, such as when you play a contact sport. In both cases, your agreement matters, but the type of harm you're agreeing to is important. However, you can't consent to harm that goes beyond what's expected or allowed, like a dangerous, illegal tackle in a game. If someone acts outside the rules or behaves recklessly, your consent doesn't protect them from being held responsible. Consent isn't a free pass for others to do whatever they want. The law sets clear boundaries to protect people from serious or unexpected harm, even if they agreed to take part in something risky. If the harm goes beyond what you agreed to, if it's more severe or completely different from what you expected, the person who caused it can still be held liable for their actions. Ultimately, the law protects your right to say no to unreasonable or extreme risks, ensuring that your consent is meaningful and that your safety is always taken seriously. Understanding provocation and consent helps you navigate real-life situations. Provocation isn't a license for violence. Walk away if you can. Consent means knowing the risks and your rights in any activity. At the end of the day, it's about respect, responsibility, and common sense.